SJC-11572, Commonwealth versus Goitia.
Good morning, Mr. Reardon.
Good morning, Your Honors. Theodore Reardon on behalf of the defendant, Mr. Goitia. The first issue in this case is that trial counsel provided ineffective assistance of counsel in his cross-examination of Amanda Arsenault, the Commonwealth's prime witness. The Commonwealth presented an argument at trial that Mr. Goitia did not want his child, did not like his child, and was hostile to his child. And this evidence came from Amanda Arsenault, who told the jury that when Naden was 3 weeks old, he was harmed while in the possession of the defendant alone. And that later, when DCF became involved, the defendant was indifferent. The defense counsel should have cross-examined Amanda on the fact that Amanda is the one who was indicted for the February incident, not Mr. Goitia. Defense counsel should have cross-examined Amanda on the fact that all of her testimony about the defendant having Naden alone in that February incident, all of that was contradicted by the statement that she gave to the police. All of her testimony about the defendant's supposed horrible relationship with his son was contradicted by that statement to the police. Trial counsel should have obtained the DCF records. Trial counsel should have obtained the defendant's parenting records. Trial counsel should have obtained the defendant's counseling records. All those records show that Mr. Goitia cooperated with DCF. They wanted him to go to counseling. They wanted him to go to parenting, and he did it. And he didn't do it begrudgingly. He did it because he loved his child, and he clearly wanted to be reunited with him.
Well, as you know, usually failure to impeach is not grounds for a motion for new trial, but in this case, tell me why this statement isn't accurate. The case really wasn't about Amanda Arsenault's credibility. It really was about the precipient witnesses testifying as to when the defendant was with the child alone and the medical evidence. So why is that wrong?
Well, that's the Commonwealth's theory.
Yeah, and I want to know why that's wrong.
Okay. The defense theory was that Naden was not injured that night, that he received his injuries sometime in the 48 hours before he died, and also that he did not die from those injuries. He undoubtedly had a very serious skull fractures, but his brain was not damaged. And as the defense expert testified, you don't die from a broken bone. So if the jury had known that this man loved his child, that he was not the one who had injured him in February, it was Amanda who was charged for that. If they had known that all of Amanda's testimony about the bad relationship was not true, and that indeed he was working with DCF because he wanted to get his child back, that this was a man who loved his child, it would go and show that it was highly unlikely that he would go and kill his child on that evening, or any evening. And the defense medical testimony that Naden was injured sometime in the 48 hours before would have much more weight, if the jury knew that this man loved his child and would not harm him. Instead, they received evidence that this man had a hostile relationship with his child, that he wanted nothing to do with this child, that he was an absent father. And that, with that kind of evidence that the jury heard, it would make it much more inclined that they would find that he harmed him on that night. So it dovetails in with the defense theory that he was not injured that night. He was injured sometime in the 48 hours before.
And we have to give deference to Judge Sweeney's findings, right? She was the trial judge and heard the motion for new trial.
Yes.
And she found that the failures to impeach were not prejudicial, correct?
She did find that, but I would suggest to you that that's simply incorrect. I mean, the defense counsel did provide some impeachment, but not on the core here. The core issue is on Amanda's testimony about the defendant's relationship with his child. And all of that tied in with the Commonwealth's theory that this man had a bad relationship and a motive to harm his child, as he had harmed him in the past. So I would just suggest to you that that finding's incorrect.
What did the jury know about the criminal charges against Amanda?
She knew that, they knew that she was charged with murder, and that they knew that she was charged with reckless endangerment, but not for which incident. She was charged for the February bruising incident when Naden was 3 months old. Later, after the defendant's trial, her complaint was amended so that she was charged with reckless endangerment for this incident.
So at the time of trial, she was charged with murder of the child and with the reckless endangerment with regard to the February incident?
Yes.
And the jury knew that, or the jury only knew that she'd been charged with reckless endangerment? They didn't know which, as to what?
Correct, not which incident.
And was there any discussion during her examination of the fact that she's testifying at trial where she's currently facing a charge of murder of the child?
It was just that you've been charged with murder.
That's it?
Yes.
There was nothing on the, on any plea agreement, there was no Champer issue that was brought up.
No, and that's the other problem, is defense counsel didn't cross-examine Amanda the fact that she had a cooperation agreement. And this wasn't any old cooperation agreement. The fact that she got up there and testified did nothing for her. This was a results-oriented cooperation agreement. If she didn't deliver results, if she didn't deliver a conviction, she got no benefit.
Did the defense attorney mention it in the closing argument?
No. No, there was not one word in the entire trial about her having a cooperation
But
agreement.
so how did it come in that she was charged with murder? Was it just oh, by the way, you were charged with murder? How did it come in?
Oh, well, defense counsel, when he cross-examined Amanda, cross-examined her about the fact that she was charged with murder. But that was it, oh, and also the reckless endangerment. But there was nothing about the cooperation.
And then didn't turn to that in the closing argument? And
No.
and didn't ask for Champer instruction?
No, no.
And the Commonwealth did not elicit anything on direct with the
No.
fact that, really, I've never heard of that.
This is the case. This is the case.
So the Commonwealth basically made no mention of the fact that the person who they're questioning is herself charged with the murder of the child who the defendant is charged with killing.
Yes. Yes.
If we could go back to Justice Lowy's question, I've not read the expert testimony. With regard to your expert,
Yes.
how does he explain the fact that the child is acting apparently ordinarily and is just fine and laughing and playing until she's dead?
He testified that if Naden had received his injuries 48 hours before, or sometime earlier, that he undoubtedly would be reacting at the time to a skull fracture, but that he would not necessarily be symptomatic during the following 48 hours. And keep in mind, this was not a brain injury. This was a fracture to the skull. So that was his testimony, that the child would not necessarily be symptomatic throughout.
Okay, but I thought your expert said that you would not die from a fracture of the skull.
Yes.
So according to your expert or your client's expert, how did the child die?
He said he couldn't tell. He said it was just inexplicable. He said undoubtedly this child had a serious fractures to his skull. Undoubtedly he had these hemorrhages, but he didn't have any injury to his brain. And he said, I can't explain to you why he died. I don't know.
Now, Amanda, she giveth and she taketh away as far as the defendant's case is concerned. And you've mentioned that the key to the case is that it could have been an earlier injury by a third-party culprit, by somebody else. Well, Amanda's testimony was really helpful in that regard for the defendant. Maybe the most helpful about all the other people in the child's life, and that the defendant spent the least amount of time with the child. Is there any way that this is a strategic decision?
No, and trial counsel submitted an affidavit to that effect. But you bring up an interesting point, is while he didn't present it as a third-party culprit, it was kind of loosely while other people were around the child. Mm-hmm. But he really should have zeroed right in on a third-party culprit as to Amanda, and this is why. Dr. Arden testified that Naden had 3 distinct sets of injuries. One set was old, months old, and healed. This was a 6-month-old child. Another set that was 3 to 7 days old and healing. Another set that was up to 48 hours old. Now, the defendant had very little contact with the child since he went into DCF custody at 3 weeks old. And Dr. Arden testified, well, of course this child didn't, the old injuries that are healed had nothing to do with his death. But we really have got to consider the fact that this 6-month-old child had these injuries spread out over a period of time. We really should be considering who's causing all these injuries in the context of who's causing the death here. So counsel had that testimony from Dr. Arden, but he didn't jump on it and say, well, make an argument to the jury, well, who was the person who had custody of Naden during all these months? Amanda. He didn't make that argument.
Well, is he excluded from visits during those time periods? The defendant?
He had very, very limited contact, and at all times it was when Amanda was
It would take a lot
there.
of contact to be able to inflict the injuries. Was he, you described 3 different time periods. Did he have access to the child during all 3 of those time periods?
He had very limited access to the child, and when...
The question.
Yeah, no, I understand. But when he did, it was never alone. It was always, he was in the custody of either Amanda's parents or Amanda.
When you say the February incident, he was not alone, is that because he was accompanied by his other child? Is that why he was not alone, or was there an adult in the room during the February incident?
Well, it was Amanda's testimony to, or her statement to the police at the time, and her statements to DCF, and her statements to medical people. She never ever said the defendant had Naden alone, and then he brought him to me, and we changed.
But my question is more specific. Is the possibility that someone else is present being he has a 2-year-old son,
Yes.
right?
Yes.
Is that why he was not alone with that baby? Or is it that there's an adult present? Because there's a big difference between whether he could inflict the injuries with a 2-year-old child there or whether he could inflict the injuries with another adult there, right?
Well, there's 2 parts to that. Number one, when he visited Amanda in February, he had his child with him, and Amanda said he didn't. That's number one. Number two,
Seems relatively irrelevant, but go ahead.
well, I think it has to do with her credibility and who she's saying. She's saying that it was just me and him alone in the apartment, and he had the child alone.
Your big point is that somebody else may have inflicted these earlier injuries, and I'm just trying to understand whether he's excluded because he's not present that month or has no visitation during that time period. Those seem to be 2 different issues.
Well, yes, but zeroing on your first comment about whether or not he was alone with Naden or with a minor or with an adult, the point is that Amanda, when she told the police about what happened about the February incident, never said the defendant was alone.
I completely understand your point. I'm just trying to get at my point, which is, can we rule out that he is not the one who inflicted those earlier injuries? Because the child is terrified of him, right? Every time the baby sees him, her lips quiver, she's, visibly frightened, right? I'm just trying to get a sense of whether maybe the person's avoiding some of these earlier incidents because your person may be the one involved in those.
Well, Amanda's testimony was that she was always with Naden, and there was never any testimony that after Naden went into DCF custody that the defendant was alone with Naden. There was no testimony to that effect. One of the points I wanted to make about the third-party culprit defense was that in addition to counsel not doing anything with Dr. Arden's testimony, had he cross-examined Amanda about the fact how she had misrepresented the defendant's relationship with Naden, it would dovetail into the third-party culprit defense because the jury would be wondering, why is she trying so hard to get this man convicted? Why is she misrepresenting the defendant's relationship with his child? And it ties in with the third-party culprit defense in that she's the one who was around during all the time that these injuries were inflicted, and she has a strong motive to point the finger at the defendant to exculpate herself in her responsibility.
So, go ahead, just go ahead.
No, thank you. Do you have any cases or where we've reversed a murder conviction for a failure to impeach, to present a cooperation agreement, not ask for a chamfer instruction, and the like?
Beyond the cases that I cited in my brief, no.
And that was the point I was going to make as well. I mean, Justice Gaziano earlier mentioned that Judge Sweeney was the trial judge and the judge on the motion for new trial. It does seem to me that it's a big deal not to have impeached with the written plea agreement. no doubt. But on the other hand, you've got the issue of a substantial likelihood of miscarriage of justice. Justice Kafka mentioned the baby physically, I don't want to overstate it, but cowering is too strong a word, but reacting when the defendant's nearby. And you have the medical evidence from the Commonwealth, and you have the evidence on the day of the death of the time that the defendant was alone with the baby. So why isn't it, just getting back to Justice Gaziano's earlier point, okay, this is a big deal, that there was no cross-examination on a number of these issues, particularly the written plea agreement, but this is a call for the trial judge that's entitled to some significant consideration.
If, under the Commonwealth theory, none of this would be a big deal. But under the defense theory, that the entire way the defendant was portrayed at trial as having this horrible relationship with his child, it all fits in with the Commonwealth theory that this man had harmed his child in the past, and why wouldn't he do it this time? But the defense theory was that he was not injured on this time, and that theory would have been strengthened if the Commonwealth's, all the Commonwealth's evidence about this supposed false relationship was all debunked. If the evidence came out entirely different, that this defendant did not have a hostile relationship with his child, he's not the person who harmed his child in February, that he had a good relationship, the defense theory that he was not harmed this night would have been significantly strengthened. And that's the argument we have.
Now, defense counsel said he simply forgot to put in the cooperation information. I'm trying to think what his explanation was.
He said, I'm not sure exactly what his affidavit says, but it wasn't intentional. He basically forgot to do it.
Okay, so he said there was no good reason. He just didn't do it.
No.
All right. If we assume that that was strategically negligent, then we get to the issue of prejudice. But it seems to me that for you to prevail on the issue of prejudice, we would have to say that the evidence that the Commonwealth offers that the child that the injuries were inflicted within the last 2 hours was not overwhelming. Because if that evidence is overwhelming, Amanda, I think the evidence from Ms. Forcier and Ms. Dabb is that the defendant was the only person who was with the child during those 2 hours.
Well, that is the Commonwealth's theory, but again, it comes down to the defense theory that all the Commonwealth's theory was strengthened by the notion that the defendant had harmed his child in the past and had a horrible relationship with him. If that was proven to be a lie, to not be true, the defense theory that he was not injured this night, he was injured on another occasion in the 48 hours before, that the defendant wasn't around, that defense theory would have been significantly strengthened.
So you're saying we need to weigh that. Your claim is that when we look at the evidence and weigh the various experts' opinion, we should give adequate weight to your own expert's opinion to indicate that the evidence that the Commonwealth offered is not overwhelming on that point.
Yes, especially whereas the Commonwealth's evidence on that point hinged on the posture that the defendant had a horrible relationship with his child and had harmed him in the past. Okay,
but at some level, if he's the only person with the child in the last 2 hours, and if the injuries were so severe that the child would have manifested them within those 2 hours, doesn't matter what his relationship is.
Well, yes, but if you consider the defense expert testimony that he could have been injured any time in the last 48 hours.
Right, I understand that. I understand. Yeah. If you get to 48 hours, you're in a different ballgame.
Right.
But if it's within the last 2 hours,
yes,
your fellow's sunk because there were 2 other witnesses who said that the only person who was with the child was the defendant during those 2 hours. Okay.
Can I ask one last question? Dr. Arden, what does Dr. Arden say about the possibility, does he put it in some kind of percentage category that a child could be on death's door 2 hours from death and not be asymptomatic? How did he describe that exactly?
Well, first of all, he said that Naden did not have a brain injury. So we're dealing with a fracture of the skull.
But the kid's about to die in 2 hours, and he's got all kinds of injuries. But I'm trying to understand what your expert testified on how he could not show any signs, even though he's 2 hours from death. So what did he say exactly? Did he leave it as a a possibility, or did he say, based on these injuries, he would be showing no signs? I'm just trying to figure out what your articulation of what's going on in those 2 hours.
He testified that this was a skull fracture, and that undoubtedly the child would be experiencing and showing symptoms at the time he suffered those skull fractures, but that he would not be continuously exhibiting symptoms for 48 hours afterwards, and that it's entirely consistent that he would be acting normally in the hours before he died. He also testified...
But it's entirely consistent, or he put it as there's a possibility that, or something like that.
A baby suffers a skull fracture and acts normally?
Not initially. No, definitely not initially. But he said that that child would not be acting abnormally necessarily during the following 48 hours. Yes. Thank you.
Okay, thank you. Ms. Lynch? Ms. Lynch?
Good morning, Your Honors. May it please the Court, Bethany Lynch, Assistant District Attorney representing the Commonwealth in this case. This case comes down to a battle of the experts. That would be the Commonwealth's position. It comes down to the timing of the injuries inflicted on this child. I would suggest that all experts, the defense and the Commonwealth's experts, agree in that the injury, in order to sustain an injury as severe as the one that this child sustained, it was a traumatic brain injury, abusive traumatic brain injury. This wasn't an accidental fall.
Can you focus in and walk us through the cooperation agreement?
Certainly.
What it said and what the evidence at trial was in the absence of champer? Just give
Absolutely.
us the start to finish on that.
The mother was also charged with murder in this case, and she did enter into a cooperation agreement with the Commonwealth, and in exchange for her testimony, that would be taken into consideration in terms of her sentencing and the disposition of her own cases.
And there's a written agreement provided
It
to
was a
defense
written
counsel.
agreement provided to defense counsel well in advance of trial. At trial, the Commonwealth did not preemptively offer that there was a cooperation agreement. Also did not ask the question whether or not she was charged with murder during direct. The defendant's attorney did ask that question. So the jury was aware that Amanda was also charged with murder in this case, and was also aware that she was charged with reckless endangerment.
And how did he raise it on cross-examination?
He just said, and to Amanda, and you are charged with murder as well, are you not? A very basic, straightforward question, and she responded, yes, I am. And the same with, and you are charged with reckless endangerment. Yes, I am. And he actually asked, and you're charged with assault and battery, and she said, no, I don't think I am, and that was an accurate statement. She was not. The defendant was charged with assault and battery, not the mother in this case. At that point, the information that Amanda was also charged was before the jury. The defense attorney did not ever specifically raise the issue, never mentioned the issue about the cooperation agreement. And I honestly have no explanation for that, for your honors. It was raised in the motion for new trial.
The cooperation agreement, your brother argues that it's unusual language about this result, and I'm not familiar with the difference.
Can I just get the
Yeah,
sequence?
okay,
We'll get
go
back if you would.
Certainly. So because there was no evidence of a cooperation agreement before the jury.
So it gets a closing argument,
No
not raised.
mention of any cooperation agreement. As far as the jury was concerned, there was no cooperation agreement. There was no
Okay.
evidence of that before them, so therefore there was no champ instruction because
instruction.
there was no evidence in the record to support such an
All
instruction.
right, if you,
Sorry.
okay, so I think Justice Caffey asked you about the content of this result-oriented cooperation agreement.
Yes, the language is cited in the motion for new trial findings by the judge, and it is results-oriented in that
And is that, I mean, again,
I've not seen that language before, but
I've never seen that language in the case. Maybe that's a strange, that seems like an odd formulation of a cooperation agreement. We got to win for you to.
I don't think it was as specific as if we don't win, you don't get any or you don't get any consideration.
What is your understanding what that means?
I believe it was an incentive for her to testify and for her to testify against the father of her child. And it was a way to, again, just incentivize her to testify as fully and completely as she could without trying to protect the defendant, which she had done in the past.
Doesn't that kind of amp up our Champa analysis when a usual cooperation agreement doesn't have such bold terms in it?
It does and it doesn't, and I would suggest for the same reason, any cooperation agreement would only go to the credibility of the witness that you're impeaching with the cooperation agreement. So the terms being stronger, I would suggest it might have made the impeachment stronger, but in terms of this particular case, the impeachment of Amanda was not the crux of the case. And so, while yes, the language was more forceful in the cooperation agreement, the bottom line was whatever, even if the cooperation agreement was as dramatic as if we don't win, you're going to prison, even still, all that would do would go to her credibility, which I would suggest was adequately impeached in other ways, and which was not as seminal a point in this case as the defendant would like it to have been. In this case, as I started out when I was saying, the case is about the timing of the victim's injuries, and better impeachment of Amanda would not necessarily, there's no direct correlation between if you don't believe her, you're going to believe my expert.
The problem, at least, it may be because I've not read the experts yet. I've just read the briefs on the experts. But it sounds like the jury is presented with these two starkly different scenarios.
They were.
One, which is that these injuries are 2 days old, and it's possible that the kid would be behaving normally. It seems counterintuitive, but it's an expert's testimony. And then your testimony, your expert who says, no, you get these injuries, and the kid's going to be a mess right then and there.
And I suggest
But then the jury is left to sort through that.
Yes, the jury was left to sort through that, and it was left to use its common sense in assessing what the experts were saying as well. The child sustained 2 severe skull fractures, and he had hemorrhages both between his scalp and his skull and underneath his skull, between his skull and his brain, of a significant size. All of that was explained to the jury by the experts and demonstrated for them through photographic evidence.
So this goes to why it was not prejudicial, and the point I think the chief made when he asked the questions earlier of overwhelming evidence or not.
Yes. The fact that Amanda was not better impeached doesn't directly impact the verdict in this case. And that is what the motion judge found, that the evidence was overwhelming of his guilt. And I can run through the evidence of his guilt. I was going to do that later in the 33E portion.
So can you give us the categories of why this wasn't prejudicial? One is overwhelming evidence, and why else?
Why the fact that he didn't impeach her with the cooperation agreement?
Right, that seems like a big deal. So what makes it not prejudicial?
Her testimony, even if it had been completely impeached and completely disregarded by the jury, would not have impacted the verdict because other witnesses gave all of the inculpatory evidence against this defendant. Again, the bottom line in this case is that what Amanda provided was the relationship and the fact that this defendant was alone and took the child by himself to put him to bed in the time when our experts say the injuries had to have been inflicted. That testimony was corroborated by at least 3 other people that the defendant was the person alone with the child at that time.
Here's the defendant's argument, though. The defendant's argument is, okay, the Commonwealth presents the evidence, we'll even call it compelling medical evidence, for the purpose of my question. But the defendant presents evidence from an expert as well that the injury was earlier, making these precipient witnesses that night not relevant, because from the defendant's perspective, we're talking about an injury that happened earlier. And then you put into the equation the prior bad act of the defendant through only Amanda, and that it eviscerates the jury's consideration of the defendant's expert's testimony that the injury was not sustained the night of the death. That's their argument. What's the response to that argument?
I would suggest that the evidence that the defendant now suggests that Amanda should have been impeached with evidence of his wonderful relationship with his son, with his loving relationship, all of that would actually have undercut his defense. His defense was, I was never around this child. I didn't have unsupervised visits with him. I very rarely saw him. I would suggest that you have the records from DCF and from his counseling. He went to the minimum of counseling and the minimum of parenting classes that he could to check the boxes in order to allow Amanda to get custody back. But he was not around this child very often, and that was the heart of his defense.
But you don't
I
need to
wasn't
be,
there.
you don't need to be around very often to inflict an injury. All you need is
do
a
not.
minute. So I'm not sure what that, and by the way, I mean, I haven't read the DCF yet, but does he actually do all the parenting classes? And I mean, does he actually cooperate with DCF? Because that's going to present him, I mean, he's presented in the light of he doesn't show up to the hospital. He's, you know, totally neglecting this child. I mean, he's, you know, when we look at the DCF records, are they going to show that the guy's cooperating with DCF and he's trying to get, and that he's contributing?
He's cooperating. As an example, he was supposed to do 10, I believe, parenting classes and 10 counseling sessions. And he did 6 and kind of was like, I think I'm done. I've gotten everything I need. So the counselor sort of signed off on it. So the implication from the counseling and the parenting records is he was going because they were making him go because they took custody.
But, I mean, having read thousands of those cases, you know, going to 6 out of 10 indicates you've got some interest in your child. So I'm just trying to get a sense is, when we go through this whole record, are we going to get a more nuanced view of his interest in this child than is presented to the jury?
I would suggest that in the records, there was one, I can recall one visit, supervised visit, after custody was removed from Amanda. Amanda had custody of the child, and custody was put in the maternal grandparent had custody of the child, and there was one supervised visit with a DCF representative there, and he showed a lot of interest in the child. But all the other testimony, and not just from Amanda, but from other people who lived with Amanda and who lived in the general area, said he wasn't around very often. They were in contact, but he didn't contribute to anything to the care of the child financially. He did not visit very often. When he did visit, the child reacted negatively to him.
What does that mean if he wasn't around very often? What does that mean for about the other the previous injuries to the child?
The injuries, there were the February injuries where he was around at that point. And then there were, the defendant's expert said that there were 2 injuries around the time of the baby's death, one 3 to 7 days before and one slightly closer in time, possibly 48 hours. Our expert said that's not true, that all that injury occurred within the 2 hours of his death. So, but again, the bottom line is that if he isn't around very often and he's not around and alone in the company of the child very often, that supported his defense that he wasn't there to inflict, whether the injuries were 3 to 7 days or 48 hours before, as long as the injuries, if the jury concluded that the injuries were after 7 p.m. on the day he died, then his entire relationship, none of that really comes into play. That only comes into play if he's trying to show that he was a great parent, he was attentive, but he didn't do enough to get himself the unsupervised visits. Amanda did. So he was taking steps, but Amanda did go and did all of her parenting classes. She did all of her counseling classes. She got unsupervised.
Did your expert sort of the reading of the briefs, it looks like the 2 experts are talking around each other. Does your expert confront the same type of evidence that their expert does about Or does he just say that this kid will have been injured within 2 hours and die? I mean, it seems like,
The Commonwealth had actually multiple experts.
Right.
And we had an expert on child abuse, we had the medical examiner, an expert on child abuse, and then an outside expert. And all of the Commonwealth's experts testified consistently that a child sustaining the severity of an injury that this child did, which was over a 4.5-inch skull fracture, which is a significant injury on a 6-month-old child, I would suggest, is they're going to be symptomatic right away. And I believe it was I know it was our expert, but I believe the numbers were in at least 95% that there would be 95% of cases with an injury like this, the victim would show symptoms immediately so that any caregiver would know.
Does their defense expert say, yes, they will show symptoms, but he's dating it 2 days earlier, and therefore they wouldn't be right before he dies? I thought that was where there's this conflict between the two of them. Am I misreading the briefs?
I don't believe you're misreading the briefs. It's more likely that the briefs were not clear enough.
But when you know the expert testimony,
I do.
Is the jury left with that gap in that, yes, he would be immediately symptomatic, but he might not be continuously symptomatic?
Honestly, Your Honor, I don't remember the defendant's expert testifying to that. I'm going to have to defer to the record on that. I just honestly don't remember whether he said that or not.
This is complicated.
I do know that our expert said that I believe he said 75% of cases he would be comatose. And in these cases, when the defendant was injured in February, as soon as Amanda saw the injury, she immediately took him to the doctor. She called her mother, she took him to the doctor, she took him to the emergency room.
In the February injury, there's bite marks.
It is bite marks.
Do we know and there's some issue about whether the other child was present. Do we know if these are bite marks from an adult or bite marks from a child?
We don't know that. And at the time it was investigated, I don't believe that the record should reflect that the child the 2-year-old was not in the apartment when Amanda said she sees the bite marks for the first time. It's just the defendant and Amanda with the baby in the apartment. The defendant takes the baby into another room. Then Amanda hears the baby start to fuss, and the defendant brings the baby back and says, I think he needs to be changed. And this is the first time that she sees.
But we should have DCF do we have DCF records?
We do. We do.
And they take away the child in February, right?
They do.
And what does the record say the condition of that child is in February?
I think that it says that he had sustained injuries that were unexplained, because Amanda did not say that she believed the defendant did it. She in fact said, I don't think he would do something like that. But out of an abundance of caution, I would suggest a baby is showing at the hospital with significant bite marks, DCF removed custody. So she never blamed the defendant at that point.
She's the one who's charged for the February incident, right?
She's charged with reckless endangerment of the child.
Oh, so she's charged with that.
Yes, which is then
But she
amended.
loses the child, though.
I'm
she
sorry?
loses the child in
does.
February.
She does. She
So
lost
the
custody.
DCF thinks that she's at least
Involved
reckless.
or
Yeah, okay.
recklessly allowed someone else to injure her child. And so the child is taken from her and given initially to her mother, and then transferred custody to her father. And her father maintained legal custody of the child up until the time of his death. And kind of wrapping back around to Amanda and her credibility, the defendant did impeach her on any number of grounds, including the number of people who would have had access to the victim in the period of time where the defendant claimed the injury happened, and also the fact that Amanda willfully violated the DCF order, that Amanda refused to give the child back, that Amanda lied to the police in numerous circumstances. So I don't want you to be left with the impression that Amanda was completely unimpeached and that her testimony would have necessarily wholly been credited by the jury in this case. And the motion judge found the same thing, and she actually listed a laundry list of various areas where Amanda's credibility was significantly questioned, including testimony by other witnesses who stated that on the ride to the hospital, when she was at that point unaware if her child was alive or dead, she was making up a story. All of that went before the jury. So Amanda wasn't an unimpeachable witness. She was very significantly impeached, just not on the issue of the cooperation agreement, which Judge Sweeney found was an error on the part of defense counsel. So she found that that was erroneous on his part, but that in light of the fact that her credibility was not the crux of the case, she wasn't the only witness against this defendant, and the fact that the evidence of the defendant's guilt was overwhelming, the lack of impeachment on that particular point did not create a substantial likelihood of a miscarriage of justice in this case.
What do we do? You tell us that the evidence is absolutely overwhelming, that this child's injuries were sustained within the 2 hours in which the only person who was with the child was the defendant, that the Amanda was not with her and could not possibly have inflicted those injuries because she was not with him at the time that those injuries were sustained, and yet the Commonwealth charged her with murder.
We did charge her with murder.
So how can you basically, again, I don't, it's not you, but it's a rather peculiar situation for you to say the evidence is absolutely overwhelming. The only person who could possibly have killed that child was the defendant, but yet we go to the grand jury and we charge her with murder as well as him.
We do, and I would suggest that as the child's mother, and the fact that she wasn't present. Our theory was at trial that she wasn't present at the time that the injuries were inflicted, but she allowed the defendant to take the child, to put him to bed by himself, knowing that he should not be doing that he had no right to be unsupervised with the child. And also, I think that some of the evidence evolved after indictment as well. We knew that both parents were present at the apartment building that night, and so I would just suggest that as the evidence flowed after at the time of the indictment, there was sufficient evidence that it could be either one of them or a joint venture. And then as the evidence developed further and the expert testimony was developed further, because the expert testimony, I would suggest, was not available at the grand jury proceeding. So in terms of that specific window, I think that testimony is what shifted the Commonwealth's theory to one defendant over the other. And that the medical evidence and the testimony of the experts as to the fact that the defendant, or that the injuries needed to be sustained within 2 or 3 hours of death, was the factor that pushed it into the defendant, overwhelming evidence of the defendant's guilt as opposed to Amanda's guilt on that point.
The trial judge doesn't describe the overwhelming, she doesn't make findings on the overwhelming evidence,
She
does
does not.
Yeah.
No, but I would
So
suggest...
she doesn't address the battle of the experts issue.
She doesn't. She does not address it specifically, but I would suggest to the court that that is a jury question. The jury heard the testimony. They saw all of the exhibits. They witnessed the testimony of the 2 experts, or the multiple experts, and it's within their province to determine which they were more like, which story they felt was more credible.
But the issue is not the sufficiency of the evidence. The issue is whether or not there was prejudice arising from the failure of defense counsel to impeach
Yes.
her with the fact that she's testifying pursuant to a rather unusual cooperation agreement.
That's true. That's
Which I think you concede that a good defense lawyer would have clobbered her and the
Would have
Commonwealth over the
definitely
head
raised it.
with, especially with this
Absolutely.
particular
Absolutely.
results-oriented provision.
Absolutely. But I would again state that even if a defense attorney did do that, and even if a trial jury completely disregarded Amanda's testimony, there still remained overwhelming evidence of the defendant's guilt in the death of this child. And so the lapse by defense counsel did not create a substantial likelihood of a miscarriage of justice in this case. And I would just finally just say that 33E review or 33 remedy is not appropriate in this case.
All right, thank you.
Thank you.
We'll take our morning break.